All right, welcome back. We're ready for panel number 2 here at the Civil Justice Symposium, the 18th Annual Symposium on Civil Justice Issues. And we are delighted that to lead our panel is Judge John Holcomb of the U.S. District Court for the Central District of California, where he's been sitting since 2020. Judge Holcomb earned his SB in Civil Engineering from the Massachusetts Institute of Technology in 1984. He went on to be a commissioned officer in the United States Navy, including assignments aboard the battleship USS New Jersey, as well as the Joint Staff here at the Pentagon. And in 1993, Judge Holcomb received his MBA from Harvard Business School and his JD cum laude from Harvard Law School. Judge Holcomb has an otherwise extensive experience and expertise as well. As I mentioned, we're going to keep the bios relatively short, so please do look at his full career as outlined at the QR code or the bio that's at the QR code that you have available on your program. Judge Holcomb has graciously agreed to lead panel 2 on federal and state civil justice legislative developments and federal and state rules committee proposals. So with that, I turn it over to Judge Holcomb.
Thank you very much, Donald. We have a lot to accomplish here today. It's a big topic, and we have 5 really distinguished speakers, so let's just get right into it. Each of the 5 here will speak for some 8 to 10 minutes, and then we'll engage in some questions, perhaps cross questions and questions from the audience. Let me start with Matt Webb here to my immediate right. As the Senior Vice President for Legal Reform Policy at the U.S. Chamber Institute for Legal Reform, Matt oversees the development and advocacy of ILR's position and policy on key federal legal reform issues, including securities litigation, preemption, alternative dispute resolution mechanisms, class action reform, tobacco Medicaid litigation, the False Claims Act, attorney fee shifting, shareholder activism, and campaign finance reform. Before joining ILR, Matt was research director for Safe Streets, a not-for-profit foundation focusing on criminal justice reform. He is a member of the Bar of the State of Maryland, and he graduated magna cum laude from America University's Washington College of Law, where he was an articles editor on the Law Review. Matt holds a BA in political science from the University of Colorado. During his free time, he's a volunteer firefighter and paramedic here in Northern Virginia. So Matt, let me pass it over to you. Thank you.
Great. Thank you, Judge Holcomb. So, good morning, everyone. It's definitely an honor to speak with all of you, such an esteemed group of judges and legal colleagues. And I'm going to be talking to you about some of the recent legislative developments in the state civil justice arena, as well as touch on some relevant state and federal court rule changes and proposals. And I'm going to provide a thematic overview of some of the key legislative changes from various states. And I'm going to focus on third-party litigation funding, asbestos litigation, as well as insurance-related and evidence reforms. And additionally, I'm going to briefly discuss a few of the significant proposals from federal and state rules committees that impact our overall judicial processes. And collectively, these changes aim to enhance transparency, reduce frivolous claims, and align several state practices with federal standards. So I'm going to start with third-party litigation funding, or TPLF, which is a topic I think you're going to be hearing a lot about during the symposium today and tomorrow. And that issue has been a focal point in multiple states this year. It's a very significant issue within the legal system, and it's one about, and as I mentioned, it's one you're going to be hearing a lot about today and tomorrow. So the first state I'm going to mention is Indiana. It's now enacted a tiered system to regulate litigation funding. It prohibits litigation investment by foreign adversaries, and it ensures that national interests are protected. Additionally, all funding agreements must be disclosed, which promotes transparency. And then one of the key aspects of Indiana's reform is the protection of sealed information from funder interference, and they're working to ensure that litigants retain control over their lawsuits, which is a very real issue and concern with litigation funding. This is crucial because it prevents external entities from unduly influencing the direction and strategy of litigation, and also interrupting the lawyer-client relationship. The next state is Louisiana. It recently enacted legislation that is focused on foreign litigation funding as well. It prohibits investments by foreign entities of concern, and their law requires that foreign funding agreements be disclosed to the State Attorney's General Office. Moreover, Louisiana's new statute prohibits any control or influence of litigation strategy by funders, again, helping to ensure that litigants maintain autonomy over their cases. This reform is particularly significant in a state where insurance rates have been skyrocketing, and there is a pressing need for additional legal reform to address those economic pressures. The next state that enacted TPLF reform this year is West Virginia. It's updated its consumer lawsuit lending laws to now include all types of litigation funding. This includes a strong automatic disclosure requirement for funding agreements, as well as prohibitions on funder control in litigation. These reforms are designed to increase transparency and protect the integrity of the legal process. By ensuring that all funding agreements are disclosed, the West Virginia courts can now better understand the financial dynamics behind the cases, and ultimately, we believe will lead to more informed judicial decisions. Now I'm going to move on to some state rule-based changes related to TPLF, or proposals. So first up is Texas. The Texas Supreme Court Advisory Committee is currently reviewing a rule proposal to require disclosure of TPLF in all civil cases. This proposal was supported by groups like the Texas Civil Justice League, the U.S. Chamber of Commerce, as well as Lawyers for Civil Justice. And it aims to enhance transparency and ensure that all parties are aware of any third-party financial interests in the litigation within the state. Again, this is a proposal that's before the Rules Advisory Committee. They haven't adopted anything yet, so kind of stay tuned there. Next up is Arizona, and they've also taken some tentative steps to address TPLF through some potential changes to that state's court rules. The Arizona Supreme Court recently set up a task force to examine Arizona's Alternative Business Structures, or ABS program, which includes non-lawyers who have an economic interest and/or decision-making authority in legal businesses. This task force last month recommended some limited TPLF disclosure as part of its report on the ABS issue. However, there are still significant concerns, at least amongst us in the civil justice community, regarding the misuse of ABS entities in mass tort litigation. In our view, these structures can be abused to solicit mass tort business and potentially limit the legal decision-making by attorneys in mass tort cases, which will ultimately lead to conflicts of interest and undermining the integrity of the legal process. So overall, these TPLF reforms collectively are designed to increase transparency in litigation funding, which will allow courts in these jurisdictions to better understand the financial dynamics behind cases. They protect litigants' rights by ensuring they retain control over their lawsuits and enhance judicial oversight, maintaining the integrity and fairness of the legal process. Next up is asbestos litigation reforms, and I'm going to be focusing on a reform enacted this year in Alabama. Earlier this year, Alabama enacted an overnaming reform to address the issue of frivolous claims in asbestos litigation. So for those of you who have not had the quote-unquote joy of dealing with the morass of asbestos litigation, overnaming refers to the practice of naming multiple defendants in asbestos lawsuits without sufficient evidence of their involvement, which causes the plaintiff's alleged asbestos-related, or causing the plaintiff's alleged asbestos-related injuries. This practice burdens both the courts and defendants with unnecessary litigation. Alabama's reforms were the result of negotiations between the Alabama Plaintiffs' Bar, as well as the defense bar and the business community, and they aim to reduce the burden of frivolous claims on the court system and defendants. For example, by requiring more stringent evidence before naming defendants, the reforms help ensure that only those truly responsible are held accountable, reducing the number of baseless claims. Next up, I'm going to talk a little bit about some of the insurance-related and evidence reforms with some examples from Louisiana and Georgia this year. Louisiana, in addition to its TPLF work this year, has also repealed its direct action statute, which allowed claimants to sue an insured's insurer directly. This change aligns Louisiana's practices with those of other states, reducing the potential for abuse. Additionally, Louisiana has updated its federal rules its evidence rules to reflect the recent Federal Rule of Evidence 702 amendments, which will help enhance the reliability of expert testimony. These amendments focus on ensuring that expert testimony is based on reliable and relevant principles, reducing the likelihood of unsupported claims. It's also worth noting that several other states, including Arizona, Kentucky, Michigan, and Ohio, have also recently adopted the amended version of Evidence Rule 702. In Georgia, earlier this year, they enacted targeted reforms on its direct action and bad faith statutes to address abuses against insurers and their insured businesses. These reforms are also designed to protect the businesses from frivolous lawsuits and ensure that the legal process is fair and efficient. These reforms, particularly the state-level adoption of Federal Rule of Evidence 702, help align state practices with federal standards, which will promote consistency in the legal system. In addition, by repealing or otherwise limiting direct action statutes, states like Louisiana and Georgia are working to reduce the potential for claimants to bypass the insured and directly target insurers, a practice which often leads to inflated claims and settlements, which drives up costs for everyone. Finally, I want to touch on a few things on the Federal and State Rule Committee proposal world. Yep. And first up is Rule 702, which I just mentioned. So a number of these changes went into effect on December 1, 2023, and by requiring that expert testimony be based on sufficient facts and data, the amendments are designed to help reduce the number of unsupported claims. We also expect more states to adopt those state-level versions of the rule. Next is proposed rule of Civil Procedure 16.1 dealing with multi-district litigation. That's currently working its way through the Rules Enabling Act process, and barring any changes, should go into effect on December 1, 2025. And then finally, there are multiple proposals pending dealing with transparency and litigation funding. I know you're going to be talking about all those later in other panels, so I'm not going to talk about those any further. But with that, I want to pass it on to my other panelists and be happy to take your questions later.
Matt, thank you very much. Let's turn to Matt's immediate right, Tiger Joyce. Tiger is the president of the American Tort Reform Association. He's a graduate of Princeton University and Catholic University Law School, and he served as the legislative assistant to then U.S. Senator John C. Danforth, and he held that position until 1984. In 1987, after being admitted to the Virginia bar, Tiger became minority counsel to the Senate Committee on Commerce, Science, and Transportation, where he worked on, among other things, product liability legislation. Tiger assumed his current position with the American Tort Reform Association in August of 1994. Tiger, please go ahead.
Excuse me. Good morning, Judge Holcomb. Thank you so much. And to the Law and Economics Center, thank you for the opportunity to appear this morning. It's a great honor for me to be here, and I look forward to your questions, hopefully at the end of this discussion. I'm going to follow Matt a little bit. We at ATRA work closely with the ILR on so many issues, and I think just a little bit of a contrast is rather than look at some individual proposals and talk about some of the specifics that are ongoing, I thought what might be the most helpful for purposes of your consideration and awareness would be to give you sort of a more of a 10,000-foot perspective on what we see coming down in 2025 and beyond. So what I thought I would do is highlight a handful of issues at a very general level, and I think it's safe to say, given the work that we do at the state level, a lot of these matters are under consideration, and we're waiting to see kind of what the prospects look like in individual jurisdictions. I think we're here in Washington, D.C. with the election close by. That affects the potential for legal reform and the reform agenda in the states next year and beyond. So all that's still a bit up in the air, but to be determined. So as I said, I'm going to highlight a few issues to give you a sense of what we see, both in terms of efforts to improve the civil justice system and also the efforts that we have seen and expect to continue to see in terms of to expand liability, matters that we obviously are greatly concerned and interested in as well. If there's a sort of single unifying issue that ATRA members are very focused on, we refer to it as phantom damages in litigation and in claims. What's the actual cost of treating someone for an injury if when he or she secures medical treatment? Is it the sort of billed amount that a hospital lists, or is it the actual amount that something is resolved for? And oftentimes there are very significant differences. If you want to look to a model, in this last year, in the beginning of 2023, Florida enacted a very significant package of reforms, AB 837, and one of the centerpiece aspects of that was what was referred to as transparency in damages. And so that, I think, will be a focus for a lot of key reforms. And as I said, we're happy to provide more detail to you through the LEC so that you can see what's been transpiring and what we would see as a model effort. The next one that I would mention is maybe a little bit different, maybe something that you even haven't considered, and that is the use or the non-use of seatbelts in litigation, whether it involves a complex design case against a manufacturer, one of the OEMs or significant component manufacturers of automobiles, or if it's just having to do with a routine, I don't want to say routine for the individuals involved, but just a collision when you have someone who's injured or even worse. There's a surprising number of circumstances where the fact that seatbelts have not been used or were misused in a set of circumstances is not admissible. We believe at a minimum that information, just as is the case in so many other factors, should be considered in matters of that nature, in cases such as those. The third that I would mention is we refer to, and I think my colleague Nino may mention this, is we refer to as jury anchoring. And that is our belief that when it comes to the presentation of evidence to demonstrate liability or to demonstrate that there is no liability, we believe that simply inserting excessive amounts and big numbers into the discussions by juries, in front of juries, we think that should be curtailed or eliminated. And I'll be the first to say that when we talk to some aspects of our membership, some of them push back a little bit and say, well, our defense lawyers think that we should be able to use numbers in that circumstance. Our belief is let's just take them out, whether it's the defense side or the plaintiff side. So that's a newer issue that we're starting to see more and more interest in, something that you might expect to see. And just wanted to, as I said, bring that to your attention. Another issue that we've been focused on over the years, I think that continues to be of interest to ATRA and I think the broader legal reform community. You've been hearing a lot about transparency. And obviously, whether it's in litigation funding, whether it's in any number of matters, we have been arguing for years about transparency in the hiring of outside counsel when state governments, in particular attorneys general, look to hire outside counsel. I used to say that a state or local government can't build 2 miles of road without putting out the proposals to do that work for the government without a request for proposals. We think that's good practice, good government. I think our view is that should apply to state governments, and now we think it's important to extend that to local governments. So obviously across the country there are different interrelationships between the state and local governmental entities, but nevertheless that's, we think, is quite important. And then I would just, as a concluding matter, I would echo Matt's comments about litigation funding. I think this has become a greater focus, not just for ATRA, but the broader legal reform community, and we look forward to collaborating with our allies around the country to work to enact reasonable reforms with both the key focus being, in addition, obviously, you heard the concern about the sort of the foreign investment angle when that comes into play. Transparency is key, but we think at the end of the day, the key driver should be who is actually controlling the litigation and whose interests are served, and ensuring that it's the parties, the plaintiffs and the defendants, and not the interests of a third party. Shifting for a moment then to some of the areas where we see efforts to expand liability. If there's a sort of a single major focus this past year, and we expect to see going forward, it's expanding wrongful death statutes around the country. Our tracking found 8 proposals, I should say, in 8 different states. Probably the most prominent was in New York. For the last 2 years, Governor Hochul has actually vetoed legislation which pretty significantly would expand wrongful death, both in terms of the time frame, the statute of limitation, also which family members and under what circumstances they can recover damages for wrongful death. It's obviously a very challenging issue, but we see that obviously as a significant focus. Non-economic damage awards, we have worked with allies around the country to establish reasonable limits on non-economic damages. That's obviously a policy judgment call, and will continue to be. We will continue to advocate for reasonable limits, but we expect to see considerable interest in both either just eliminating them or significantly increasing limits. Statutes of limitations, this is probably the most challenging issue that we at ATRA deal with, but there have been efforts around the country to expand statutes of limitations retroactively in cases involving childhood abuse and now so-called adult matters as well. And our view is that the issue is the retroactivity for defendants and, to be candid, their insurers to be subject to liability for matters when that took place years and even sometimes decades previously is challenging. Dealing with that prospectively, obviously to the extent that the criminal law can come into play, we think is highly appropriate, but it's the retroactivity that we're seeing that we feel quite strongly about. A couple of more quick things that I would mention: arbitration efforts in the around the country at the state level, as well as we've seen in the at the federal level, to either eliminate or limit the use of pre-dispute arbitration. Our view is that the civil justice system requires reasonable and effective alternatives to full-blown, costly, and expensive litigation. And then the final matter that I'll mention is just as a general observation is private rights of action, sort of embedding in statutes efforts to establish independent causes of action where we believe oftentimes that is excessive. I know that my friend Phil Goldberg is going to talk tomorrow about public nuisance and also the expansion of state Consumer Protection Act reforms. We are seeing that public nuisance, we believe, is not being properly utilized oftentimes in litigation and also as a pretext to expand the reach of state consumer protection statutes. But I'll leave the details of that to him, but just to give you that perspective. And those are what we believe are both the affirmative and also problematic efforts that we expect to see in 2025 and beyond.
Tiger, thank you very much. Let me turn to Tiger's immediate right, Sue Steinman. Sue is the Senior Director of Policy and Senior Counsel at the American Association for Justice, the AAJ, where she advocates to protect the Seventh Amendment right to trial by jury and represents the rights of injured people to have their day in court. With a deep knowledge of tort and civil procedure issues, Sue is responsible for the strategic management of complex policy issues for AAJ's internal and external stakeholders. Sue leads AAJ's engagement with the Judicial Conference, which is the policy-making arm of the federal courts, and she understands how small changes to the Federal Rules of Civil Procedure and Federal Rules of Evidence impact cases in federal and state courts. Sue oversees AAJ's Sections and Litigation Groups Department, a community of practice-specific networking and resources to help trial lawyers learn from each other. She's also responsible for developing civil justice research grants for the AAJ Robert L. Habush Endowment for facilitating research and education projects to protect access to justice. Prior to joining the AAJ, Sue served as legislative counsel for the Montgomery County delegation to the Maryland General Assembly and as a bill drafter for the Maryland General Assembly. Sue holds a law degree from GW, right here in DC, and a BA in political science from Tufts University. Sue, please go ahead. Thank you.
Thank you, Judge. I'm happy to be with you today. I have never spoken on one of these panels before. To my colleagues to my left and to the audience, the American Association for Justice is the membership bar association that represents the plaintiff side of the aisle. We disagree with everything that these guys just said. Rather than responding point by point, I'm going to talk about Federal Rules of Civil Procedure and what I do at the Judicial Conference, which is my area of expertise. However, at the end, if you ask me questions, I can respond generally. The American Association for Justice does not advocate at the state level. We have state trial lawyer associations that do that work. I will say this, all of our policy positions are based on supporting the Seventh Amendment right to trial by jury. And so, for example, when there's talk about anchoring or other things about jury evaluation of damages, we believe that juries who hear a case and who hear from expert witnesses who are there to help the jury evaluate damages, they're able to come up with an amount, and that is the purview of the jury. And those are not appropriate restrictions to be passing at either the federal or the state level. So I just want you to have that framework in mind as we begin our discussion. Now, I want to switch to the Judicial Conference. The Judicial Conference, of course, is the policy-making arm of the federal courts. They have a committee on rules of practice and procedure. It's called the Standing Committee, probably because their name is too long. And they have 5 advisory committees that do the actual work. The advisory committees are appellate, civil, criminal, evidence, and bankruptcy. And we do work in front of most of them, except really bankruptcy. And I want to talk about how these proposals get to the committees, and then we'll talk about a couple of the proposals in detail. The proposals can come from all different sources. Sometimes the committees come up with them because they're trying to resolve a circuit split, and that would be an appropriate thing for them to resolve. Sometimes they come from a judge who has run into an issue and they want the committee to come up with a solution. Law professors submit questions. Our trade associations submit things that we would like them to resolve. And so they come from a variety of places. The advisory committees come up with a draft rule, and then they go to a comment period. The comment periods are pretty lengthy. They're 6 months long, and then they go back for a final polishing. Right now, there's a public comment period on amicus briefs. It's from the Advisory Committee on Appellate Rules, and it's Federal Rule of Appellate Procedure 29. Why is this rule interesting? It's because it was instigated by Congress. As you may know, Congress doesn't really do very much these days, and sometimes they punt their issues to the Judicial Conference to solve. I want to mention this rule because it is somewhat controversial already, even though we are only a couple months into the 6-month comment period. Why is that? Everybody seems to be for disclosure, but sometimes maybe they're not really for disclosure. On one hand, there are people like Sheldon Whitehouse, who has a bill also in favor of disclosure in Congress, who thinks the rule should have additional disclosures. And then there are people like Senator McConnell, who think that the disclosure requirements are violating amici's First Amendment rights. From a more practical perspective, AAJ and also the Washington Legal Foundation, who we never agree with, have some practical concerns about this rule. Well, what would those practical concerns be? For one thing, if you are filing an amicus brief in federal court right now, you can get permission to file from either the court or, more likely, consent of the parties. This rule would get rid of the consent from the parties, and that would put a lot more burden on the courts themselves. We have concerns about the impact of this. So this is something to watch going forward. And why should you, as state court judges, be concerned about this? Because a lot of times, if something's adopted at the federal level, eventually it will trickle down to you and you'll be dealing with the same issue later on. I want to mention two more rules. One is a rule that will be, the Advisory Committee on Civil Rules is meeting this Thursday in Washington, D.C. They'll be looking at Rule 41, which is dismissal of action by plaintiff. This rule is to resolve a circuit split. Some circuits let the plaintiff dismiss the claim and keep the action. Other circuits require the plaintiff to dismiss the entire action. This goes to the point about asbestos claims. Well, why does the plaintiff name so many defendants and sometimes so many claims? It's because you don't know who's done what until you've had some discovery. This is particularly relevant in civil rights cases, and we've seen a lot of it even in the state of Virginia, where a person who was in police custody had a mental health breakdown, then was taken by the police to the hospital where they were having an anxiety attack. They were not being violent, and 7 police officers and 3 hospital employees jumped on the person, and they died of asphyxiation. The claims against the police department have been resolved, but the claims against the hospital remain. And so the rule needs to be updated so that the claims can be dismissed that have been resolved, and the claims that are still ongoing remain in the case. So that's an example of where resolving a circuit split would be a good thing. Finally, I want to address privacy. All the advisory committees together are collectively deciding whether there needs to be an update to Rule 5.2, which, let me get the right title here because I wrote it down. Privacy protections for filings made with in federal court. There's been a lot of people writing in AAJ, the National Crime Victims Bar Association, the DOJ, the Department of Justice, urging action to update this rule. It seems that it's possible that they will not, the advisory committees may not take any action at this time. We think that would be a mistake, but there are a couple things I want to point out to you because the public really wants you as judges to be mindful of privacy issues. One of the issues in this rule is the use of the last 4 digits of people's social security numbers. If litigants and parties don't need their social security numbers, let's skip that. There's a way to discuss social security numbers between counsel without putting it in the record. I think that's a really important thing for you all to be considering. The other thing I want to mention is the use of minors' initials. Minors' initials is something that you can use, but you shouldn't. You should be using a pseudonym, a gender-neutral pseudonym, and that protects minors from sex traffickers and people that have caused them abuse. It is much harder for the people causing abuse to find them. And then what you want to do is also refer to the parent by the child's pseudonym. So parent or guardian with the pseudonym. It does provide a lot of protection. Thank you very much. I'm going to wrap up, and I'm happy to answer other questions about rules or about policy positions more generally.
Sue, thank you very much. Let's turn next to Nino Marchese. Nino serves as the Director of both the criminal justice and civil justice task forces at the American Legislative Exchange Council, where he works closely with state legislators to aid in the development of impactful criminal and civil justice model policy. Arranging various sorts of educational briefings, Nino provides insight and advisory opinions on the most pressing judiciary matters throughout the states, all while working to de-silo state legislatures from one another. Nino began his career in policy work in the office of U.S. Congressman Thomas Massey, serving as the director of the Congressional Second Amendment Caucus, where he structured priority issue briefings and advised on Second Amendment-related legislation. He is a graduate of the University of Central Florida. He was born and raised in Tampa. He earned his BS in political science as well as a certificate in intelligence and national security. Nino is also a part-time law student, currently earning his JD right here at GMU's Scalia Law School. Nino, take it away. Thank you.
Thank you, Judge, and thank you, everybody. Honored to be speaking with you all today. First, I just want to give a little bit of background about what ALEC is, because we are a bit of a unique organization. We're a nonprofit, nonpartisan voluntary membership association of state legislators. So we have about 25% of the nation's state legislators as our dues-paying members. So I have the privilege of working with them alongside organizations like ILR and ATRA to help them develop, strong model policy, civil justice policy in the states. Our Civil Justice Task Force has been doing this work for about 5 decades now. We have dozens of model policies which touch on many of the issues that our panels have spoken on here today. One of which, and I'll touch on this briefly because I want to get into some bit different topics today, but Federal Rule of Evidence 702, Matt talked about that. I think the session before us has spoken about these changes at the federal level. States are also mirroring this. We've seen them carry this work, and it's something that they're interested in updating as well in their state rules. More recently, Ohio and Kentucky and Missouri did so by court rule in 2024. Arizona did so in 2023, and Louisiana did so this year as well through statute. Third-party litigation finance, phantom damages, and jury anchoring are relatively evergreen issues that we've seen in the states for the last 5 to 10 years. Our members are continually interested. The state legislators I work with are interested in tackling those issues. So we anticipate that more legislation will be coming down the pipe in the years to come on that. But today I want to shift focus a little bit because we have quite a few tort experts on the panel here. So shifting from that a little bit, I want to talk about some more separation of powers issues that are impacting you guys in the states and also in federal courts. The first one is administrative law judges, and then I want to get into judicial deference. So just very briefly, by a show of hands, how many of you are familiar with the administrative law court and law judge process in your states and how that all works out? Okay, great. That's very helpful. So often if an individual or business finds themselves in an accused violation of a rule in their state, they have to start this very lengthy, arduous process, oftentimes mandatory, before they can actually bring a claim in the judicial branch. This touches all industries and activities. Primarily, we've seen, in particular, financial services, environmental, pharmaceuticals companies being impacted by this the most when they're roped into these different adjudications by their state agencies. The problem with that isn't so much that there is an executive body handling this and you have experts in the executive branch handling those disputes. It's how the law is applied and carried out. A lot of the times, executive rules and regulations, they're interpreted law that are then applied, and sometimes many would argue they go too far in their interpretation, and that law is what's being applied in those administrative hearings. And further, if you're on the losing end of that decision by the administrative court, I say court in quotations because they're not in the judicial branch like you all, the appeals process is also very one-sided too. So oftentimes they're appealing to the very body of individuals that were on the original body of jurisdiction themselves. And so it's a very one-sided game. And so we've seen a lot of legislators and judges be interested in seeing how that process can really be shifted over to the judiciary itself like it should be. It's no secret. Sue pointed out herself, there's different sides of the whole tort arguments and whatnot. And a lot of the businesses that we work with are definitely more so leaning on the defense side of the game. But now what we're seeing, this administrative law judge issue has become so prevalent in our members' minds that they're actually wanting litigation to come forward quicker, because sometimes they'll try to start that process, and the judicial branch of the court will say, you must first exhaust all of your options through your administrative appeal process prior to any litigation commencing. And so companies wanting lawsuits to start more is a sign that this has become a very, very arduous process. So Alec, we developed model policies. Hopefully you all had a chance to read those readings that we added. I was a little late to the agenda, added to the panel a little late, so we added those readings later. But those model policies don't come from staff, they come from our members. We have a very democratic workshopping process where we develop these models. The one that we have, it touches on and says that it's basically trying to create an independent agency and body in the executive branch. So rather than have your State Department of Agriculture, State Department of Financial Services, or what have you, and an administrative court in that body, create a whole separate independent administrative law judge or law court that's accountable to itself, separate from the bodies that are designing the law, implementing the law, and enforcing it. There's a chief judge appointed to preside over those courts and hire law judges, which also have to meet requirements. One, they have to be attorneys, and they have to be licensed in the state to practice, which is not always the case. I'll tell a really quick story. My first year of law school in Indiana, not George Mason, I'm a transfer student. I had my study group, had about 3 other guys in there, and we all get to know each other over the course of the first semester, sharing what we do for work and whatnot. And administrative law judges comes up because this is an issue I work on in my job. And I was basically teaching them and educating them about it because it was the first time they had ever done anything legal, being law school for them. And it was mostly just conversational, but the more opinionated study partner of mine was particularly quiet that day. Fast forward about 6 months, it's one of our last classes of the semester, and I turn to him and I say, Emmett, what do you do for work? And he says, I'm an administrative law judge and I issue SNAP benefits. So this is a 1L student, friend of mine. He's not an attorney, and he was appointed by some bureaucrat. And that's the case in a lot of states. So a lot of these law judges, they're not attorneys, they're not judges, and many of them probably haven't even set foot in a courtroom. Yet we're abdicating a lot of this judicial authority to interpret our laws and adjudicate to the executive branch, and not even necessarily to adjudicate statutes, but regulations that bureaucrats are creating. So our model policy seeks to create that independent body to make the process more fair, to have some accountability, and ensure that administrative law judges have a final decision on a matter in a way that doesn't create such an arduous appellate process. In North Dakota introduced a bill like this. We've seen successful reforms in Indiana, if you're looking for a model to look at. HB 1003 of 2024 in Indiana implemented this model, and we're anticipating several more states to follow suit. And I might be running out of time, so I'll move quickly through deference. So I know we're all familiar with Chevron deference, the death of Chevron deference in particular through Loper-Bright. The message I'm communicating to our members right now is an emphasis that this only touches federal courts. I mean, unless you have some Erie doctrine, Federal Administrative Procedures Act embedded in a state law claim, Chevron, or rather Loper-Bright, is not going to touch the state courts. The deference argument, the deference battle, reform battle has been going on in the states for some time now. But more recently, states have become more active and much more interested in this. And I think it's for the same reasons and the same spirit behind why people care about administrative law courts, because it all comes back to the separation of powers. Who's writing our laws, who's interpreting them and enforcing them, and who is adjudicating and interpreting that law. And so states are now really trying to do their own versions of Loper-Bright and overturn Chevron through their court systems, but also through the legislature. And so just this year alone, we've seen 3 states overturn Chevron statutorily, Indiana, Nebraska, and Idaho. Only 15 states, however, explicitly prohibit their courts from deferring to agency interpretations when unclear. 8 states explicitly require deference, so that's Chevron deference, mandating that deference. And just a quick show of hands, where are my state judges at? Great. Well, you guys have been so inconsistent in your opinions on a judicial deference that we don't even know, in the remaining states, where exactly your states stand on deference, even though it's not mandated or not prohibited. So basically, judicial deference is still very much alive in at least 35 states. So there's been successful reforms, like I mentioned, in Idaho, Indiana, and Nebraska just this year alone. In 2024, we saw introductions into Iowa, Louisiana, and Oklahoma. And in 2025, I know of one bill in Illinois that's coming up, but we're anticipating to see many, many more states follow suit, especially through their legislatures. But as the legislatures move, I think judges like you all, hopefully, and other courts are going to look to changing that deference standard. So I think I'm over time, so I'll pass it over now. Thank you.
Nino, thank you very much. Let me turn last but certainly not least to Alan Butler. Alan is the Executive Director and President of the Electronic Privacy Information Center, also known as EPIC, here in Washington, D.C. Alan joined EPIC in 2011 and served as Interim Executive Director during 2020. Prior to his appointment as the Executive Director, Alan managed EPIC's litigation, including the Amicus program, and filed briefs in emerging privacy and civil liberties cases before the U.S. Supreme Court and other appellate courts. Alan has argued on behalf of EPIC in privacy and open government cases in the U.S. Court of Appeals for the D.C. Circuit, the Third Circuit, and the Supreme Courts of New Mexico and New Jersey. Alan has authored briefs on behalf of EPIC in significant privacy cases, including an amicus brief in Riley against California that was cited in the Supreme Court's unanimous opinion upholding Fourth Amendment protections for cell phones. Alan has he's also authored briefs on national security, open government, workplace privacy, and consumer privacy issues. Alan is also chair of the Privacy and Information Protection Committee of the ABA section on civil rights and social justice. Alan is a graduate of the UCLA School of Law and Washington University in St. Louis, where he earned a BA in economics. He is a member of the D.C. Bar and the State Bar of California. Alan, please go ahead. Thank you.
Thank you, Judge. And thanks to the faculty at George Mason for having me here today. So my co-panelists here all have, I think, a pretty wide spectrum of issues that they work on, and I'm the kind of odd duck on the panel that has a very narrow focus. As the judge mentioned, I come from the Electronic Privacy Information Center, and we're a nonprofit research and advocacy center that focuses on data privacy and constitutional civil rights issues related to personal information and privacy. A lot of folks, I think, watching this symposium probably have interacted with privacy issues in different aspects, but the ones I will be focusing on today, in my brief remarks today, are primarily in the vein of civil actions brought under state and federal privacy statutes, and in particular on legislative developments and proposals around those areas and other issues related to accountability for online data collection and other online platforms. So I'll start with a discussion of recent federal and state proposals under the ambit of what I'll refer to when we talk about as comprehensive privacy legislation. And the reason I emphasize the comprehensive is because historically here in the United States, we have a mix of federal and state statutes related to privacy, as well as general tort and civil causes of action. But many of those privacy laws that are enforceable in the federal and state vein are quite narrow in scope, and so we end up with what is sometimes described as like a stovepipe system historically, where you have, one federal privacy bill that concerns the privacy of videotape rental records, which now applies to online streaming, and another one that applies to the privacy of DMV records. And so we end up with this historically very, at the federal level especially, kind of stovepipe system. And really, there's a 50-year effort underway to bring data collection and data use policies under a single, broader, comprehensive umbrella. At the federal level, there has been significant debate around full-blown legislative proposals on the comprehensive front for 25 years. But most importantly, in the last 5 years, there's been substantial work done in Congress in a bipartisan way on a set of proposals that have come through first in 2022 in the American Data Privacy and Protection Act, worked on primarily out of the House Energy and Commerce Committee in a bipartisan way by the leadership there and Kathy McMorris-Rogers and Frank Pallone. And then an evolution of that legislative framework this year in the American Data Privacy Rights Act. That was a bipartisan bicameral legislation, sort of led on the Senate side by Chair Maria Cantwell in the Senate Commerce Committee, and on the House side by Kathy McMorris-Rogers. The comprehensive privacy legislation, both at the federal and state level, generally covers a wide range of issues related to personal data, including individual rights of access, deletion, correction, as well as data security and data breach issues, limitations on the collection and use of data. Some of you who watched the webinar with the Supreme Court preview for this term may note that the first case that was discussed, which was actually a shareholder SEC disclosure suit, was fundamentally about the Cambridge Analytica Facebook breach. So it was a privacy case in a sense coming through a different vein. And then also the comprehensive privacy legislation includes provisions related to discriminatory uses of data and accountability in that front. And at the core of that bipartisan framework is fundamentally a set of compromises that bring all sides to the table, that include a private right of action in the federal bill and preemptive effect on state law. And that's something that in both contexts, there's been in the last 5 years a lot of heavy debate and compromise over different sub-provisions. But essentially, you're looking at an effort to create a uniform national standard for privacy law that is enforceable through a private right of action. We've seen a number of states take on that mantle in the meantime. The Congress has not passed that provision, even though it's advanced significantly in the House. And states have kind of filled that void by taking on their own proposals that are modeled after that set of compromises and agreements. This year, we saw those proposals introduced and carried forward in Maine and Vermont and Maryland. The law passed in Maryland without a private right of action, ultimately. The law in Vermont passed the legislature but was vetoed by the governor. It did include a private right of action. And the law in Maine got very close but ultimately did not pass. What we saw and what was documented in a really quite breathtaking hearing held by the Vermont legislature was documentation by state lawmakers of the immense lobbying campaign that those individuals and their legislatures and governors faced in the late stages of that effort by industry lobbyists that were really pushing against, in particular, the private right of action. And I think this gets to the crux of what this discussion is about, which is the role that private right of action plays in enforcing and making effective consumer protection legislation. Because ultimately, even though many states have passed privacy laws in the last 5 years, I think we're up to about 13 or 14 now, the ability to meaningfully enforce those laws, if it falls solely on the state's Office of Attorney General, is very limited because most states do not have a privacy or identity protection division or data security division within their Attorney General's office. They don't have the knowledge and resources to stand one up. The state of California is an outlier because they have, through their legislation that was passed in 2018 and amended in 2020 through a citizen ballot initiative, they have an independent privacy agency stood up in the state with its own authorities and its own budget and expert staff. And that's really unique. Only Colorado kind of begins to approach that with at least a division within the Attorney General's office. But that division in Colorado, in contrast, is only a few staff members and does not have its own separate and independent funding and authority. So that's one of the reasons why the private right of action is seen as such an important element within privacy legislation, because without it, there's really a fear that the law will be in name only and won't actually be made to effect and made to be enforceable. Another thing I'll mention at the state level is that there was one of the most effective, I guess, and evidence of the point I was just making, is one of the most effective state privacy laws we've seen in the last 20 years is the Illinois Biometric Information Privacy Act, which was passed, I think, long before most folks in even legislatures and others knew how much of an impact it would have, because of the significance of the sensitivity of biometric information in particular, and it includes a private right of action. It has been used to bring strong enforcement actions against companies that were unlawfully collecting biometrics. So Illinois amended that statute to limit damages for multiple instances of unlawful collection of the same information, and to make a few other tweaks, but the law otherwise still is on the books. The last thing I'll mention before we skip the discussion is that there is a separate set of proposals or discussions happening about, on the flip side, about immunity against litigation under Section 230 that affects online platforms, and a constant debate around that, including in federal Congress, where there are a number of proposals that I'm happy to discuss also if that's of interest, but I'll just stop there.
Alan, thank you very much. Before we get into questions, do any of you panel members wish to respond to anything one of the other ones of you said? Anybody feel compelled to respond? Okay, well, let me, there's going to be Matt brought up the issue of third-party litigation funding, and a few of you have touched on it. I know there's going to be a whole panel on that, but let me throw out a provocative position and get your respective takes. Why does it matter? So the cases I see, for example, a patent case, plaintiff is a non-practicing entity, perhaps it's funded by some third party. I don't necessarily know at the beginning, but why does that matter? What matters is the patent infringed? Are the claims infringed? Are they valid? Are they invalid? If the defendant is infringing the patent, what remedies are appropriate? Is an injunction called for? The damages? Isn't that the critical thing? Why does it even matter who is funding, if anyone, a third party, the plaintiff here? Is this a solution in search of a problem? Why is that not the right view? Who wants to respond to that?
I'll start the
I thought
discussion
you
on
might.
it. Well, I mean, a couple things. One, I mean, let's get down to the first level of who's actually controlling the case. We've seen multiple examples in the litigation funding space, both in the intellectual property world as well as in other types of litigation, where the funder is actually the one that is the real party, or effectively the real party in interest. Judge Connolly, who's the chief judge in the Federal District Court for Delaware, has put in place a standing order in his courtroom requiring disclosure of all third-party litigation funding, but he's actually gone very deep in some cases where he's actually found that the funders are affirmatively trying to keep themselves hidden, have basically put up potentially sham plaintiffs to bring the patent litigation to the point to where he's actually referred things to the Department of Justice for possible prosecution. So
forgive me for interrupting you,
Yeah.
but it's what I do. It's what we all do.
that's what judges do.
That's what we're good at.
Yeah.
Let me interrupt one thing. Can you pull the microphone
Oh,
closer to you?
Okay. How's
So,
that? Okay.
my question is, why does it matter? That is, certainly for recusal purposes, the judge needs to know who the real party in interest is in case he or she has some sort of a financial interest. But let's assume that can be satisfied. Why does it, if that's satisfied, if recusal is off the table, if that's not an issue, why does it matter?
Okay, well, I mean, first of all, you do need to know who the real party in interest is. Let's start there. Second, as you're looking at the case to figure out who needs to be in the room when you're trying to talk about settlement, if there's somebody who's pulling the strings behind the scenes, Normally, I think most judges tend to want to have everybody there who has that decision-making authority or requirement. In addition.
For settlement purposes?
For settlement purposes. In addition, for litigation fairness, because both sides need to know, for example, on the defendant's side, I mean, there's already a requirement to, at least at the federal level, to disclose your insurance policies as they relate to the litigation. In some ways, the TPLF is very similar, but does not have an equal disclosure requirement. In addition, when you're looking at folks who are really, and this is more of a philosophical thing, is really, I mean, what they're turning litigation into is strictly an investment and turning the court system into the New York Stock Exchange. And that, I mean, that's, at least from my organization's viewpoint, that's not what the court system is supposed to be. And at least need to have some level of disclosure so you know that those parties are actually present and actually potentially pulling the strings.
So again, let me be provocative. Why is that a bad thing from a free market perspective? Why is it necessarily bad for claims to be traded?
Well, I think one is, I'm looking at it from a much more traditionalist, originalist sort of point of view, where the court system's designed to resolve disputes. It's not an investment system. So when you have folks that are investing in litigation, it has a tendency to distort the system. You end up with potentially questionable claims being brought because it's not a question of who did right, who did wrong, has a real claim. It's really designed to figure out who's going to get the biggest return. And again, that's not, at least from our perspective, that's not what the court system's designed to do. It's designed to resolve disputes. And I think that's kind of where we would fundamentally disagree with that sort of thought process as far as how the court system's really intended to be.
All right, thank you. Anybody else care to weigh in?
Judge, we agree with you.
Well, it's not me. I'm
This,
just,
this obsession with TPLF is making a mountain out of a molehill. Look, if this is just a business model that some plaintiff law firms use to have enough money to run their cases. The defense bar is really well-funded. This is corporate America. Most plaintiffs don't have the same level of resources, and it's simply a funding mechanism to level the playing field. And if there's an issue about whether the litigation funder has undue influence, which is not in the interest of the plaintiff lawyer, and the plaintiff lawyer does not want the litigation funder running the case. That is for sure. There are members of AAJ on different panels throughout the day. Feel free to ask them this question. I see one of them sitting in the back. There's a way to handle it. You can have in-camera review of the litigation agreements. You can bring these people behind the scenes and ask them what's going on. The reason why it's not good to have all of this publicly disclosed is it really gets into the strategy of the case. And that's really the reason why the defense bar wants all this information. And it really hamstrings the ability of plaintiffs that don't have the same resources to be able to take on really large corporations. Thanks.
thank you. Anybody else?
I would just say if it's a molehill, then shouldn't be a big deal to put it out there so we know what exactly you're dealing with.
Yeah, well,
I think there's the unknown unknown. If I'm presiding over a case, I would want to know in great detail who's there and who's engaged.
Okay, are there questions folks want to ask on the microphones? You got there first, so go ahead, sir.
Lucky me. Thank you. Excellent panel. I sit in the bankruptcy court for the District of New Jersey, and we've seen, obviously, like all my colleagues in our bankruptcy courts, waves of tort cases, of diocese, sexual abuse cases, talc, asbestos cases, opioids. The one thing they all have that seems to be burdensome is an explosion of meritless claims that impede our ability to have oversight over these cases. And what I'm pointing at is claims that have not been vetted, that are I guess the product of tremendous advertising, but they impact the selection of lead counsel for on committees. They impact leadership in MDLs. They certainly impact voting and how we handle cases. And this is a question for the panel. Are there any state, federal, regulatory efforts, legislative efforts to try to ring in some of the, or require more extensive vetting of claims before they're pursued in the judicial forums?
Well, I'll start. There are a number of reforms in that area. First of all, and I know I'm kind of harping on this, but litigation funding reform would be one of the first ones, because funding is used for a lot of the advertising. And at least if you start getting disclosure of funding, you at least start having an idea of who's doing the advertisements and what have you. In addition, there's starting to be an acknowledgement at the state level of the need for truth in advertising in a number of these circumstances. So when you have ads, and this has happened more in the pharmaceutical context than some of the other cases or types of cases, where it's almost looks like the FDA has recalled a particular drug or something like that, or put in places a basically very questionable, bordering on possible, I don't want to say fraud, but just untruth advertising. And some states like West Virginia have put in requirements that there basically needs to be truth in advertising in those types of cases. Again, not saying that they can't advertise, but it's just that it needs to be a much more clear and truthful representation of what the litigation is about. But the other thing I think that needs to be looked at in the asbestos context, again, it's overnaming. Sue mentioned the need to actually, because you don't know who's actually in the case, but the problem is, at least in the asbestos context, is that everyone under the sun gets named. And you have somebody that is either, and I'm not making light of someone who has mesothelioma. By no means am I doing that. But when you have a case where this person has allegedly been exposed to every company in the United States that has some history of making asbestos, that it kind of boggles the mind that someone is that incredibly unfortunate that they've been exposed to everybody. And they don't have any evidence that there's been that sort of exposure. So when you put in things like overnaming requirements, that you have to have some indicia that they have a true exposure to a particular company's product, then you actually get the real parties and interest in front of the courts, rather than everybody.
Can I
Go ahead, please.
put some little information into this discussion? Judge, I agree. Our members should be vetting their claims. And if they're not, that needs to be addressed. I don't think it's an issue with third-party funding. I think it's an issue with these lead generators who are doing the advertising. So I just want to be clear about what the cause is. Sometimes, and there are a couple of different issues with this if we want to break it down. One is that with the lead generators, sometimes the plaintiffs themselves call several different firms. And so multiple firms have filed on behalf of the same plaintiff, and those firms don't know that they have the same plaintiff in their representation files. So there's a problem with figuring that out early on. And it doesn't mean that those claims are frivolous. It just means that at the end of the day, that plaintiff only has one claim in the case, even though maybe 3 or 4 law firms have filed on behalf of the same plaintiff. So that happens. The second issue is what Matt was alluding to, and that is the issue of not knowing whether, in a product liability case, if that plaintiff was injured by that particular product or they were injured by a similar product, whether the products line up, and sometimes that takes a little bit of discovery. We had a very robust discussion about early vetting of claims with the MDL rule that was recently finished. And this is a really tricky situation. At the end of the day, the advisory committee decided not to address it in the rule, and some of the judges who weighed in on it said that this is really tricky. For example, in the 3M in the 3M case, there was a lot of discovery that took an extraordinarily long time. Well, why is that? Because you're talking about veterans, and their medical claims were coming from the Department of Veterans Affairs. And so that medical information about who had what earplugs and when, that took an extraordinarily long time. So in certain cases, it's really hard to come up with a one-size-fits-all rule, but we are open to having discussions about what would be fair. It's just that when you think about particular cases, they don't all fit into one category.
Can I just say that I think the reason you're facing these claims is because of this very issue, the sheer volume of claimants. That becomes, at least from our perspective, the driving force. So there ought to be, and I appreciate the comments that Sue made, you want to, in good faith, try to find out who really does have an injury and what creates at least a viable claim. But right now, I think there should be widespread agreement that that's not working properly. And I think the effort to try to deal with that, my guess is that it's going to, and I think it's you all presiding over litigation should be demanding that we have a more efficient system so that that cases can be handled more appropriately and that don't look for alternatives to handling cases through regular litigation.
Thank you. Let's get another question in, please.
This question's directed to Sue and Tiger, only because I think you're going to disagree, and I want to start a fight. And Matt, you can jump in if you want to help Tiger on it. But anyway, I'm a Florida judge, circuit court judge, and you know we have this new statute, 768.0427, where dealing with phantom damages, where the legislature has decided to direct that the evidence of the medical bills, past medical bills, should not be the amount that's being billed, but it's the amount that the health insurance company would pay, or the amount, if they don't have health insurance, it would be 100%, 120% of the Medicare rate. And that's what gets boarded to the jury as the medical bills. My question to you is, well, the plaintiff has signed a letter of protection with the medical provider agreeing to be liable for the full amount of the bill, and we all know they're exaggerated. I'm not going there with that. You know, it used to cost $75,000 to have a cervical fusion. Now it costs $200,000, and then the doctor wants to recover the full amount. The plaintiff wants it on there because they want to show a $200,000 bill to get the pain and suffering that matches the bill. So the plaintiff is trying to show, the bill. Now they can't. But what happens to that poor plaintiff, and I know I'll get a reaction from Tiger and Matt on this, what happens to that poor plaintiff who now has a LOP signed to that doctor to pay that $200,000 bill, and they only get $30,000 because of the new statute, which says specifically that's the amount that goes into evidence?
Well, I would say the first response is that's prospective. So at least it would only be it would only apply in cases filed after, I think it was towards the end of March.
Right. It's the new cases.
Yeah.
But, I get a motion to strike based on the contract, Article 1, Section 10, that it's interfering with the contract between the doctor and the patient. Do I declare it unconstitutional and move forward? And I know Tiger has an answer to that, and Sue may have a different answer.
Well, I would just say, and then I'll defer to Sue, I think that's a matter that perhaps they can resolve outside of a decision and strike something that's equitable. I can't say it's in the sort of that hypothetical. Is it unconstitutional? I think absolutely the legislature considered, and this is broader policy. Sue talked about sort of having just sort of roll it all out in front of the jury and let them decide. We think obviously the jury makes the decision. However, we think that the legislature considered a lot of factors. This is not a new issue in the state. This isn't something that crept up January 1 of 2023. It's been an issue of concern, and the legislature and the governor took the action that they did.
So Tiger, you would say that the medical bill comes in, and then the Medicare rate comes?
I'd
I
have
need an
to-
answer.
I'm not sure I could give you an answer. I'm not facile enough on the details of exactly how that would play out.
And that's going to have to be the last word, because we're at time. Sue, I'm very sorry.
It's
But
all good.
I'm confident that anybody who has questions or wishes to engage any of the speakers here in more detail, you're going to be around for a little while, I assume. Okay, great. Thank you very much to all the panelists. And thanks to the LEC for having us.